Okay, here we are with FCA, free carrier. FCA is the first member of the F family. As you can see in this picture, the scope of responsibilities on the seller side has increased a bit. You can see that the seller has to deliver the goods at a premises from the buyer's side, and the risk of transfer continues to that point. The freight charge definitely is on the seller until that point, and also logically the seller will insure the goods because the responsibility and the risk is on him. Then the story goes like this: the goods must be delivered on truck, ready to be unloaded, so the unloading is on the buyer and buyer's agent. Okay, once more to clarify, according to the book, the free carrier FCA Incoterms 2020 rules pushes the responsibility of the delivering the goods to the buyer's nominated premises onto the seller. So they have to organize shipping and various export documents, contrary to Ex Works. In international trade, the word free means up to what part of the delivery the seller is responsible for the goods. According to what you heard, the export formalities in FCA is on the seller. A1 General Obligations. In each of the 11 rules, the seller must provide the goods and their commercial invoices as required by the contract of sale and any other evidence of conformity, such as the analysis certificate or weight bridge document, etc., that might be relevant and specified in the contract. Each of the rules also provides that any document can be in paper or electronic form as agreed in the contract, or if the contract makes no mention of this, then as is customary. The rules do not define what electronic document form is. It can be anything from a PDF file to blockchain or some format yet to be developed in the future. B1 General Obligations. In each of the rules, the buyer must pay the price of the goods as stated in the contract of sale. The rules do not refer to when the payment is to be made: before shipment, immediately after shipment, 30 days after shipment, half now and half later, or whatever, or how it is to be paid, like a prepayment against an email of copy of documents, on presentation of documents to a bank under a letter of credit, or other arrangement. These matters should be specified in the contract. So all in all, do not rely on the Incoterms, none of the Incoterms, about the payment terms. Even as a seller or as a buyer, you must rely on the contract for these items. A2 Delivery. The seller delivers in one of two ways. Number one, if the named place is the seller's premises, then when the goods have been loaded on the means of transport provided by the buyer is the delivery point. This includes, of course, the buyer's carrier, but allows the buyer to collect on its own vehicle, such as in a domestic sale. The word loaded here would usually mean safely placed on the vehicle. But for example, if the pallets or crates are loaded on a truck, then any tying down or lashing will be the responsibility of the vehicle's driver under safety and traffic rules. If the goods are loaded into a container on the back of a vehicle, it would reasonably be expected that the seller would lash and secure the goods. As in Ex Works, the seller would need to inform the buyer of any specific location, such as its own warehouse, contract manufacturer, or a particular loading dock. Any restrictions at the site need to be communicated too. If, for example, the loading dock needs to be accessed through a car park, it might be that a 40-foot container on a trailer cannot be brought close to that dock. The second form of delivery in FCA. If the named place is not the seller's premises, then when the seller places the goods at the disposal of the buyer or its carrier on the seller's vehicle, delivering the goods to that place but not unloaded. Clearly, the seller cannot be expected to provide the means to unload the goods into, say, a carrier's terminal, nor would they be allowed to for safety, security, or insurance reasons. This delivery must be made on the agreed date or at the time nominated by the buyer within the agreed period, or, failing these, at the end of the agreed period. Why at the end? Because before that, the buyer could still inform the seller of his desired time within the agreed period. B2 delivery. The buyer's obligation is to take delivery when the goods have been delivered as described in A2. Note that this rule does not discuss the means of transport at all. It merely mentions the carrier regardless of how the carrier will arrange the transport of the goods. The point we have to talk about here is that the details of delivery, such as exact time, needed facilities and equipment, must be communicated. According to the term articles, the buyer is obliged to take the delivery when the goods are at the disposal to be delivered to him. But in case the buyer fails to communicate the unloading requirements, and due to this failure, the buyer fails to take the delivery, then the seller is responsible for the failure. And all occurred loss of time and money will be on the seller. Delivery in FCA gets complicated sometimes. I remember I was at an airport to export some products, and I witnessed some complicated case with two companies. The merchandise which was supposed to be exported was a merchandise of 2,000 canaries, and the seller had forgotten to prepare a document to let the officials get enough information about the merchandise and let it inside the warehouse. It was a hot summer, and because of that failure in providing that document, and because they had to wait about an hour to bring the original copy of the document from their office to the airport, I witnessed like 400 or 500 birds dying there, and because of this failure, the buyer was not able to take the delivery. It was tragic, and I remember that the buyer and the seller were just quarreling about the case, but the reality was that because of this failure from the seller's side, the buyer was under loss, and also a lot of birds died. When the merchandise is something sensitive or something that wasting time can be a harm to them, you have to be very careful about the documents and the certificates that you need to do the customs affairs in the customs, if you are the seller or even if you are the buyer, but you have to be careful about the delivery in FCA. A3, transfer of risk. In all the rules, the seller bears all risk of loss or damage to the goods until they have been delivered in accordance with A2 described above. The exception is loss or damage in circumstances described in B3 below, which varies dependent on the buyer's role in B2. B3, transfer of risk. The buyer bears all risks of loss or damage to the goods once the seller has delivered them as described in A2. Additionally, if the buyer fails to have its carrier or another person give the required notice under B2, or that person fails to take the goods from the seller, then the buyer bears all risks either from the agreed date or time, or if no agreed date or time, then at the end of the agreed period. For example, if the contract states the delivery must occur in June, so the seller has the goods ready at their premises to place on a truck provided by the buyer's carrier, and that carrier informs the seller that he will collect the goods on the 20th day of June, but fails to do so, then buyer bears all the risks of loss or damage to the goods from the end of the contract period being 30th of June. The point I have to mention is that if due to any failure from the buyer's side for taking the delivery, the goods are harmed while they are on the truck, then the buyer is responsible. If the goods are harmed during the unloading process, clearly the buyer is responsible. In some cases, it is not clear whether the parts or the products have been damaged during the unloading, or maybe they have been damaged during the transfer from the seller to the buyer's premises. So in this case, the buyer, while unloading, has better to film the case. I mean, in order to prove that there has been no problem while unloading, you better film the procedure of unloading. A4, carriage. In this rule, the seller has no obligation to the buyer for arranging carriage of the goods. The seller, however, does an obligation to provide the buyer with any information in its possession, including any transport-related security requirements, and requested by the buyer at its risk and request. The seller's responsibility for any transport-related security requirements is only up to delivery. So if the seller trucks the goods to the carrier's premises, then transport-related security requirements for that leg only are the seller's. Keep in mind that if there is any special requirement for loading the goods and unloading the goods, it has to be communicated between the seller and the buyer. Otherwise, any failure will be on the seller. Okay, next paragraph. In some instances, the seller and buyer can agree for the seller to contract for carriage, possibly because it can obtain more favorable rates than the buyer could, but such carriage is at the buyer's risk and cost. While the rule states that the contract for carriage is to be on the usual terms, it is mostly likely that the two parties will agree in their contract exactly what those terms are. Actually, about this paragraph, I should say that in all cases, this is the buyer who pays for the carriage. But the difference between this case, I mean FCA, and like CIF or CFR case is that in FCA, even if the carriage is contracted by the seller, the price of carriage, I mean the freight charge, will not be inside the documents, because in that case the term will change and the conditions will be violated. Before carriage, the buyer must arrange for the carriage of the goods, whether by the buyer itself or a contractor carrier at its own cost from the named place of delivery. This allows for the buyer itself to take delivery of the goods, such as might occur in a domestic transaction. The exception is where, as stated in A4, the contract for carriage is arranged by the seller. Note that the contract of carriage needs to be specified as to where it commences. Remember that in A2, there are two places of delivery can occur, either at the seller's premises loaded on the collecting vehicle, or not unloaded from the seller's vehicle at another place, which is typically the carrier's premises. The note I have to put here is that in the case the carriage is contracted by the seller, it makes no change in the risk transfer point. It's true that the seller is arranging the carriage, but the risk transfers exactly according to the delivery point of the goods, which was mentioned in A2. A5 is about insurance. We read the text. The seller does not have the risk beyond the delivery point, so it has no obligation to the buyer to arrange a contract of insurance. However, if the buyer requests at its risk and cost, the seller must provide the buyer with information in its possession that the buyer needs to arrange its insurance. If there is any information which the buyer requests that is not already known to the seller, logically, the seller can and probably would choose to assist. Nevertheless, and this is not covered by the Incoterms 2020 rules, a wise seller would investigate taking out marine insurance on a contingency basis. If the goods are lost or damaged in transit and the buyer therefore refuses to pay for them, in essence breaching the contract, the seller will want to have a fallback of being able to claim its own marine insurance. First of all, let me tell you something. From the seller's side, this is true that the seller is responsible for the products until the delivery point, but as we read here, it is logic to buy the marine insurance, which will help you in a case of damage in transit, or if for any reason the buyer walks away from the trade. In this case, of course, let me tell you that we don't do this only because of the things that we know and the things that we can speculate. We also do these things to tackle the problems that we have not seen yet. You know that the world is changing and people are always using new techniques, and you don't know really what the buyer or if you are the buyer, what the seller had in its mind. So you have to be careful with this item. And I would always buy such an insurance if I want to export a product. On the other hand, if you are the buyer and you want to buy a product based on FCA, I would propose to buy a full insurance from the seller's warehouse to the buyer's warehouse. And according to the rules related to insurance, if there are two insurances for one merchandise, the one which has an earlier date will be in power. But in any case, insurance plays a very important role in these cases. B5 says, despite having the risk of loss or damage to the goods from the delivery point, the buyer does not have an obligation to the seller to insure the goods. Whether the buyer chooses to insure the goods or bear the risk themselves is entirely their choice. This is another proof for the sellers that they should be careful about the insurance. You know, if anything happens in transit or in any other place where the buyer is responsible for their safety, and something happens to the goods and then the seller will be under loss, the seller cannot complain because the buyer has no obligation to insure the goods. So be careful. A6. Delivery and transport documents. The seller at its own cost must provide the buyer with the usual proof evidencing the goods have been delivered to the buyer or another person, most usually, of course, its carrier, in accordance with A2. What form that proof takes is a matter for the parties to agree in their contract of sale. It could be as simple as the buyer's signature on a copy of the invoice through a forwarded cargo receipt or anything else agreed. If the buyer requests, the seller must assist the buyer at the buyer's risk and cost in obtaining a transport document. Where the buyer has instructed its carrier to issue a transport document to the seller under B6, for example, a bill of lading or airway bill, and it is in negotiable form, such as a bill of lading consigned to order and in multiple originals, the seller is obliged to present a full set of those originals to the buyer. This will usually be along with other shipping documents presented to the seller's bank under a letter of credit issued by the buyer's bank. Okay, so in FCA, at the delivery point, the title of the product passes to the buyer. So it is important for the seller, if the trade is done through a letter of credit, to receive the full set of bill of lading from the seller's agent, the carrier, at the delivery point. Then, according to the LC regulations, when the documents are presented to the seller's advising bank, they will be sent to the buyer's advising bank consequently, and the LC will continue its way. B6. Delivery transport document. The buyer must accept the proof provided by the seller that goods have been delivered as described in A2. Here comes the problem of inspection. So the buyer is supposed to check what is stipulated in the documents and what is loaded. This is a problem. When the parties have agreed in their contract that the seller is to be given a transport document stating that the goods were loaded, such as an onboard bill of lading, the buyer must instruct its carrier according at the buyer's cost and risk. So in the case of a letter of credit, this is important because an onboard bill of lading is a document which has to be provided to the advising bank to release the payment. So this part is important because an onboard bill of lading is a document which the bank needs to release the payment. So the buyer and the seller must agree on this in their contract, and the buyer must instruct its carrier to provide such document. A7. Export and import clearance. This rule, like all the multimodal rules, is suitable for both domestic and international transactions. Where applicable, the seller must at its own risk and expense carry out all export clearance formalities required by the country of export, such as licenses or permits, security clearance for export, pre-shipment inspection, and any other authorizations or approvals. The seller has no obligation to arrange any transit import clearances. However, If the buyer requests at its own risk and cost, the seller must assist in obtaining any documents and/or information which relate to formalities required by the country of transit or import, such as permits or licenses, security clearance for transit import, pre-shipment inspection required by the transit import authorities, and any other official authorizations or approvals. This is an advantage over Xworks for FCA because, as I told you before, in Xworks, since the seller has no control on the export formalities, there are some risks. So in FCA, there are advantages for both the seller and the buyer. For the seller, because they can assure that the goods are declared as they are in the export formalities, and for the buyer, it's an advantage because some buyers do not have enough connections to cover the export formalities in country of origin. B7. Export-import clearance. Where applicable, the buyer must assist the seller at the seller's request, risk and cost, in obtaining any documents and/or information needed for all export-related formalities required by the country of export. This is applicable where the country of origin, the officials, should make sure that the country of destination is allowed to buy a specific product, and if the company who's the buyer is allowed to buy that product. You know that for some specific products there are some limitations. Because of that, maybe the seller needs some documents from the buyer to be able to export the products. Where applicable, the buyer must carry out and pay for all formalities required by any country of transit and the country of import. These include licenses and permits required for transit, import licenses and permits required for import, import clearance, security clearance for transit and import, pre-shipment inspection, and any other official authorizations and approvals. They are the buyer's responsibility because they occur after delivery by the seller. At first glance, it might seem strange that both seller and buyer have responsibility for pre-shipment inspections. To clarify, the seller is responsible if it is a requirement of the country of export, and the buyer is responsible if it is a requirement of the country of transit or import. A8. Checking, packing, marking. In all rules, the seller must pay the cost of any checking operations which are necessary for delivering the goods, such as checking quality, measuring the goods and/or packaging, weighing, counting the goods and/or packaging. So, as we told you before, at the delivery point, when the proof of delivery is supposed to be signed by the buyer, this must happen, and the checking company, which is an international inspection company usually, must provide a report. The seller must also package the goods at its own cost, unless it is usual for the trade of the goods that they are sold unpackaged, such as in the case of bulk goods. The seller must also take into account the transport of the goods and package them appropriately, unless the parties have agreed in their contract that the goods be packaged and/or marked in a specific manner. So according to this, if the buyer asks a special packaging for the products, the extra cost over the standard export packaging is on the buyer. B8. Checking, packing and marking. In all rules, there is no obligation from the buyer to the seller as regards packaging and marking. There can, in practice, however, be agreed exceptions, such as when the buyer provides the seller with labels, logos, or similar. In such a case, when the buyer is supposed to provide a label, whatever related to packaging, if the delivery is delayed because of the buyer's failure in providing such items, there is no liability on the seller for this case. A9. Allocation of costs. The seller must pay all costs until the goods have been delivered under A2, except any costs the buyer may pay as stated in B9. The seller has to pay any costs involved in providing the usual proof that the goods have been delivered. So if the contract between the parties state that proof as being a bill of lading or an airway bill, then the carrier's document fee is on the seller. The seller pays any costs, export duties, and taxes, where applicable, related to export clearance. If the buyer is requested by the seller to provide information or documents to assist the seller in their export formalities, then the seller must pay the buyer for these costs. B9. Allocation of costs. The buyer must pay the seller all costs relating to the goods from when they have been delivered, other than those payable by the seller. If the seller has been requested by the buyer to provide assistance in obtaining information or documents needed for the buyer to effect carriage, import formalities, insurance, and the transport document, then the buyer must reimburse the seller's costs. Where applicable, the buyer pays any duties, taxes, or other costs for transit or import clearance. Additionally, and provided the seller has advised that the goods have been clearly identified as the good under the contract, the buyer pays any additional cost incurred if the buyer fails to nominate who is to take the goods from the seller or that person fails to do so. So up to here we understood that up to the delivery point all the costs are on the seller. But this only covers the basic costs. If any special needs from the buyer, such as a special packing, which may require a special procedure, these things will be on the buyer. 10 notices. Even though the buyer arranges its carrier or another person to take delivery of the goods, the seller must give the buyer sufficient notice that either the goods have been delivered or that the carrier or another person has failed to take delivery within the time agreed. Yes, notices and communication, sufficient communication is vital in international business. So, whatever happens, the seller must not wait for the carrier or the agent to provide this information to the buyer. And the seller automatically and according to the rules must notify the buyer about what has happened. B10 notices. The buyer must notify the seller of a number of things so that the seller can deliver and carry out any export formalities. These are contact details and location of the carrier or another person who the seller is to deliver to, the selected time, if any, in the agreed delivery period, such as when a container terminal is accepting cargo for a particular vessel, or when an airline requires cargo for a specific flight, the mode of transport and any transport-related security requirements. Yes, the same as A1, which talks about the liability of the seller to send notices to the buyer. Here the buyer is also liable to send the seller the information needed to export the products. So in case these notices are insufficient, either from the seller side or from the buyer side, any delay or any problem occurred and any cost coming from that point will be on the party who has failed to provide the required notices. Points to keep in mind. Number 1, the named place can be the seller's premises like X work, but the difference is that in this situation the seller will be responsible for loading while the buyer will arrange the pickup. Also, the export formalities will be on the seller's side. 2. As the seller is the one who takes care of the export formalities, it has access to the bill of lading which is needed for banking procedure in the bank when the seller wants to collect the amount of DLC. 3. The buyer is responsible to unload the merchandise if the named place is out of the seller's premises. When the goods delivered loaded on the means of transport out of the seller's premises, the unloading is not on the seller. 4. The seller must provide the proof of delivery when it is done on its cost, and the buyer's agent must accept to sign and stamp it if there is a full conformity between the delivered merchandise and the contract of sales. If the payment is to be done through a letter of credit, then the bill of lading is needed. 5. The title and risk transfers to the buyer when the goods are delivered, whether the named place is the seller's premises or anywhere else. 6. FCA must be used by the buyers who have a good relation with shipping companies in the country of origin, and they are confident they can get a better offer than the seller. So if you are a new buyer with low experience, choose a better term such as CPD or CFR. 7. FCA is a good term for the seller too. While all costs related to the delivery and export formalities are added to the invoice, the seller has a good control on the documents needed to proceed for the banking affairs. 8. FCA is more preferred for the road or air shipment from the buyer's point of view. In ocean shipment, if anything goes wrong with the export formalities on whom the buyer has no control, and since the terminal charges in the port of origin is on the buyer, It can lead to unexpected extra costs. 9. You must specify the name place like FCA Hamburg X Customs Container Yard, not FCA Hamburg, because it includes a wide area which will lead to complications. Most of the conflicts in regard to FCA arise from the unclear place of delivery. If any damage is occurred during the delivery, it isn't clear who is liable for the damage. 10. As we said before, FCA means goods delivered at the named place ready to be unloaded. So if the seller is present at the delivery point but the carrier company is not able to unload the goods due to any problem on its side, and during the time the seller is waiting for the carrier to unload the goods a damage occurs, then we will have a conflict. So the seller must prove by some document that the truck was there but the carrier did not unload the goods. This document can be a receipt of the goods stamped by the carrier company. 11. If there are any special equipment needed to unload the goods, the seller has to inform the buyer and the carrier in order to avoid any delays or difficulties. 12. According to the revision in 2020, the seller can ask buyer to advise its carrier to issue an onboard bill of lading to the seller for the matter of advising bank's request at the time of collecting the LC amount. This item, 12, is repeated several times in this video, and that's because of the importance of the case. So in order for you not to forget this item, we'll repeat it several times.